I extend a very warm welcome to you all to today's webinar on company securities and insolvency law updates. Friends, it is indeed my pleasure, privilege, and honor to host this program. Today's webinar is very important for all professionals because each professional wants four things in my view. Number one, he wants to track the regulatory changes. He doesn't want to miss any regulatory change. He wants to keep track of the forthcoming regulations, forthcoming changes in laws. He wants to know what would be the impact of the changes in regulatory framework or the proposed changes in regulatory framework. He wants to prepare his company that what would be the impact on the activities of his company, what preparation he has to do, and how he has to implement these changes in order to comply, in order to be compliant. To meet this felt need of all professionals, corporate professionals decided to host the first webinar of every month to cover all the regulatory and legal updates on company securities and insolvency law. We have a panel of experts who are experts in regulatory framework, legal experts who share their insights and experiences and take us through the latest legal and regulatory updates and how these impact us and our companies. I extend a very, very warm welcome to the galaxy of today's speakers. We have Mr. Amit Gupta, a practicing company secretary and insolvency professional. Ms. Anjali Agarwal, partner and head capital market services corporate professionals. Shri G.P. Madan, founder Madan Law Offices and co-chair SOCHM MMA Task Force. Mr. Manoj Kumar, partner and head M&A and transactions corporate professionals. And Ms. Nikita Vijay, senior associate, securities laws and corporate litigation corporate professionals. I'm sure today's webinar will provide a valuable platform for learning and discussion. And I'm sure all of us will gain a better understanding of the recent regulatory and legal updates in the field of company securities and insolvency law. I once again welcome you all. I'm sure the webinar will be very informative and engaging. Please keep posting your queries and our experts will be very happy to take up the same. May I now invite Shri G.P. Madanji to take us through recent case studies and proposed amendments in IBC. Over to you, Madanji.
Thank you, Agarwal sir. Welcome my co-panelists and all dear participants for joining this webinar on this Thursday afternoon. Sir, I have decided to cover two very, very important judgments, very, very recent one. Under Insolvency and Bankruptcy Code. One is with respect to applicability of Section 138 of Negotiable Instrument Act vis-a-vis Insolvency and Bankruptcy Code. Now, what has happened in a particular case? The promoter of the company issues a check on behalf of the company from the account of the company. This check gets dishonored. This check was worth 6 crores of rupees. Check gets dishonored because there were no funds in the bank. Now, sensing that some action may be taken by the other party, no doubt an action is taken. Section 138 complaint is filed. Now, sensing that tomorrow there may be some trouble for the company and the promoters, the company files Section 10 application. Like recently, Go Air filed Section 10 application. We call it now, it is being called voluntary insolvency. So that application is filed under Section 10. Immediately after filing Section 10 application, this MD of the company who was signatory to the check, he files another application under Section 94 of the code. That is application by the debtor as personal guarantor to the corporate debtor. PG to CD provision have been notified. So under PG to CD, either the debtor can file an application, personal guarantor can file application, or the creditor can file an application. Both the options have been given. And once an application is filed, the interim moratorium kicks in under Section 96 of the code. Now, on the one hand, Section 10 application is pending. That has not been admitted so far. Now, the promoter, the MD of the company, files an application under Section 94 so that the moratorium kicks in as far as he is concerned. So, he files Section 94 application. And the beauty of 94 and 95 application is, till the time this application gets submitted, the interim moratorium starts. While there is no provision of interim moratorium in case of company, in case of CIRP. But in case of personal guarantors to corporate debtors, interim moratorium is there immediately on filing of the application. Interim moratorium means no proceedings can be initiated against the applicant, against the guarantor, or no other proceeding can be further proceeding can be initiated. Existing proceeding will get stayed. Now he files this application 94 so that 96 moratorium is there. Now, after filing this application, now he approaches the district court, where Section 138 proceedings are going on. And there he says, now I got the moratorium. So 138 proceedings cannot continue against me because I have got the moratorium. It's not a CD has got the moratorium, CD application is still pending. He says, I have got the moratorium because I have filed a Section 94 application. So 138 proceedings cannot continue. The magistrate dismisses this petition, this particular argument of the applicant, managing director, and dismisses that application for this moratorium. Against this order of the magistrate, now this particular managing director approaches Delhi High Court. On 15th of May, Delhi High Court had very elaborately dealt with this subject. And Delhi High Court has said that under Section 141 of Negotiable Instrument Act, if a check has been issued by a company, then proceedings can be initiated against its directors, managing directors, secretary, manager, or whosoever is at the helm of affairs of this company. And this person is called a natural person. So here in this case, 138 proceedings have been initiated against a natural person who happens to be managing director of the corporate debtor, who happens to be signatory to the check. These 138 proceedings have not been initiated against the MD in his capacity as personal guarantor. So no immunity shall be granted. This moratorium, which is there under Section 96, will not get extended to this managing director as personal guarantor. Court has further said, had he issued a personal check, had that check been bounced, and 138 proceedings are initiated against this individual in his individual capacity, then this proceedings, then 196 moratorium may be granted. But here in this case, it was not a personal check. It was check issued on behalf of the company. So therefore, he is there as a natural person under Section 141 of Negotiable Instrument Act. So moratorium under Section 96 will not get extended to this managing director as a personal guarantor because he is a natural person. The court has very beautifully put, I would like to read that paragraph, that petitioner is seemingly trying to escape his liability by trying to urge that his application under 94 in his individual capacity would stay the complaint under section 138. It is clear that petitioner is facing criminal proceedings for being signatory to the check which has been dishonored. He is covered under natural person under section 131 of Negotiable Instrument Act. The debt in the present case is not of the petitioner, but that of the respondent to, that is corporate debtor. So therefore, what they have tried to say is that he is trying to take undue advantage of this moratorium of section 96. Hence, it cannot be granted to this personal guarantor because this proceeding is not as a personal guarantor. Personal guarantor will kick in when the company goes into insolvency. Abhi the company ki application pending, a section 9 has not been, section 10 has not been admitted so far. So those provisions will not come into picture and he is not entitled to this moratorium. This is one case study, sir. The second case, I would like to read that number of times this insolvency professionals, IRPs or RPs, they face a very, very great hardship whenever an admission order gets stayed. Here in this case, what has happened? A bank files an application under section 7 against the corporate debtor and the application gets admitted. Now, against this admission order, the promoter of the company files an appeal. And in the very first hearing, the appellate authority passes an order that operation of the admission order will be stayed. I'm repeating this word, sir. Operation of the admission order will be stayed. And according to appellate authority, no action in furtherance to the admission order can be taken now. Now, what does it exactly mean? Whether a company comes into original position, whether CIRP is there or not, whether if CIRP is stayed, whether IRP has any powers or authorities or not, whether moratorium is there or not during this period, during which this admission order gets stayed. Actually, that final appeal is yet to be disposed of. Only interim order has been passed. Now, in the meantime, what happens? One of the banks of the company, he adjusted some around 40 crores of rupees against the outstanding dues. That money is lying in the account of the company and the bank adjusts that money against the outstanding dues. Now the directors file an application that this is a clear breach of moratorium because admission order has been stayed only. But moratorium still there. So during moratorium, no adjustment can be there by the bank. The appellate authority says, sorry. When the original admission order has been stayed, it means there is no moratorium. Actually, there was no clarity on this till date. But now the appellate authority says there is no moratorium at all. Company remains in its original position. The directors can run the company. So as if the company is running, company is a going concern, company is having its own operations, directors are running the company, no moratorium at all. And the further appellate authority says, once we say that the operation of the admission order will get stayed, no further action shall be taken in furtherance to that admission order. It means even moratorium is not there. IRP cannot take any action. No COC will be constituted. No COC meeting can be there. Company will be governed and run by its own board of directors and not by the IRP. So moratorium is not there. Actually, promoters of the company filed a contempt application against the bankers that they have adjusted the money. But court says, sorry, no question of any contempt because the moratorium is not there. So at least some clarity is there because a number of cases we have seen that the admission orders are stayed. And then there is no clarity whether IRP can take any action or not, RP can take any action or not. In the meantime, moratorium will be there or not, whether IRP or RP is entitled to the fees or not. Even those clarities are not there. The third, which is not the case, but is one of the proposed amendments which is there and has been the highlight during last 3-4 days. Actually, in the month of February, Ministry of Corporate Affairs came out with a discussion paper on the proposed changes in the Insolvency and Bankruptcy Code. And it is learned that all those proposed amendments shall be tabled before Parliament in this forthcoming monsoon session. But another media report has been there. No doubt media report has come out from the government only. And now there will be a proposal in case of real estate insolvency cases. Whether during when the CIRP is on, all those allottees who have paid their money and who have got their possession. Actually, on possession, they are not clear whether possession they are not. But if all entire money has been paid, can the IRP or RP get the lease deed or sublease deed or the sale deed, as the case may be, executed in favor of this buyer? And can the particular transfer document be registered? Till date, there was no clarity. If you ask me personally, according to me, this particular flat is nothing but a stock of the company. And if entire payment has been made, it can be transferred. The lease deed can be executed, sale deed can be executed, it can be registered. But there was no clarity. Many of the IPs are not taking this action, that tomorrow there may be some disciplinary action from the board, or there may be some penal action from the adjudicating authority. So to provide a clarity to this, there is a press release, or not press report, I'll not say press release. There is a press information that in the proposed monsoon session, there may be an amendment that during the CIRP period, the registry of the flats can be done, and the IRP or RP shall facilitate the registry of these transfer documents in favor of the allottees. And if it happens, it will be major relief to the allottees, who now they will not have to wait till the end of the CIRP period. And during that period, they will have the registry done, and they can take possession. They can start living in there, so that they will not be having some interest burden, or if they are living on rent, at least they'll stop paying that rental. It will be a big relief to the home buyers. These were the three short submissions from my side, 2 case studies and 1 proposed change. If any question is there, I'll be more than happy to take the question right now, because at the end I may not be available here, sir.
Thank you very much,
Sir, somebody has asked the question. Delhi High Court of Section 138. This order is passed on, judgment is pronounced on 15th of May 2023 by Honorable Justice Jasmeet Singh, and this is miscellaneous criminal petition 381 of 2022. 381 2022, 1727 of 2022, and 13434 of 2022. So these are the 3 numbers. We note it down. Justice Jasmeet Singh. Names of the parties are Sandeep Gupta versus Shriram Steel Traders and others. I'm repeating the citation again. The title of the case, Sandeep Gupta versus Shriram Steel Traders and others.
Thank you very much, Madanji, for beautifully covering very interesting orders. Thank you very much for supporting our initiatives and being available with us.
So I always treat myself as part of the team, sir.
Thank you. Thank you very much for your benevolence.
Thank you. Thank you. So I wish all my panelists and all the participants very best for the rest of the proceedings. And I'm really pleased to see the smiling face of Ms. Anjali Agarwal also. Thank you.
Hello, sir.
Friends, we held our last updates webinar in the month of May. And during that webinar, we had discussed the changes made in the companies, removal of names of companies from the register of companies, amendment rules, popularly what we call the strike-off rules. And during discussions, we had pointed out that there will be some practical problems. We are very happy that MCA has been very quick to take note of the anomaly in the new amendment and has come out with another amendment to remove the difficulty. I'll request Shri Amit Gupta ji to take us through this new amendment in the strike of rules. Also, friends, although we have already had a detailed webinar on the two notifications issued under PMLA, but this being a very important development, I'll request Amit ji to quickly take us through these two notifications for the benefit of participants who could not attend our earlier webinar. Over to you, Amit ji.
Good evening, sir. If I am audible?
Yes, Amit ji.
Yeah, I am keeping video off. I am suffering some low bandwidth issue today. So maybe I'll try if it works, then all right. Otherwise, I'll again switch off. So, as we have discussed other day also, with regard to the strike off, let us understand the background also, why government is so very keen in doing necessary reforms with regard to the closure process or providing the faster mechanism for closure of companies, which is a point of key concern for the regulators today, because they don't want to burden the regulatory framework in respect of companies which are actually not doing any productive activity. So they have enabled in the system, and there is nothing new, because that provision was there in the section 560 of the 1956 Act, and same provision was incorporated in section 248 and along with couple of other sections also in Companies Act 2013 to discuss and provide a permanent mechanism, because in section 560 there was no direct provision wherein company suo motu can file the application. However, time to time, Ministry of Corporate Affairs has been bringing the exit schemes. One of the scheme which got very popular was fast track exit scheme, where Government of India through Ministry of Corporate Affairs provided a scheme wherein company on suo motu basis was able to file the application for this strike off. Now, this is a permanent provision in 248. Now, 248 is also divided into two parts. One is suo motu application on part of company, and the other is the suo motu action on the part of the regulator. So 248, one deals with action on part of the regulator on happening of certain events, and 248.2 is a window which is available to the companies who qualify the conditions which are specified in section 248.1 to file an application and get the closure. Now, before we jump into the discussion of striking off, it is also important to understand what are the options available for a company to close the business. Company can close the business by getting a dissolution order, maybe on voluntary winding up, or which is now called a voluntary liquidation under section 59, or maybe a winding up in terms of the provisions of section 271 of the Companies Act 2013, or maybe on declared insolvent in terms of the action
Amniji, audio is not coming.
Sorry, I got disconnected, so I have parallelly connected on the mobile also. Sir, if I am audible here.
Recording in progress.
Amit, you're audible, but
All
your
right.
voice is echoing, doubling, because you're
Yeah, now it will, because it was parallel on two system. Now it should be okay.
now it's fine. Yeah.
All right. So we were discussing just that we have parallel mechanism, multiple mechanism for closure. We discussed that we have an option of voluntary liquidation under section 59 of the Insolvency and Bankruptcy Code, section 271 of the Companies Act 2013, which is a NCLT driven process. And now one third option is which is through insolvency, where section 7, 9, 10 applications are filed. And if resolution does not happen, the company goes into liquidation and finally the dissolution order is passed. So these are the three channels which are available for dissolution. Now, fourth channel that is available as on date is a strike off of the company from the register of companies maintained by the respective registrar. Now, government is stressing on the fourth option, as I had explained earlier also. The reason is very clear, that government knows that the other options, except the voluntary liquidation, which is in section 59, the other options are quite time taking and they are not fast track. So to give the exit opportunity to the corporates, the government has recently set up the C-PACE Center, the Center for Accelerated Closures of the corporate entities. That is set up in the Manesar, where the centralized registrar will be monitoring and taking necessary actions for closure of these entities. Eligibility norms remains the same. He will be empowered to take actions under 248(1) and he'll be empowered to process the applications under 248(2), both. Now, on the last part, why government is so focused, as I discussed, because the other processes are quite time taking. And if a company was set up or incorporated, but virtually could not do any business, or has no plans, or it is an abrupt abortion of the business plan, there needs to be a process by which company can close its operation in the easy manner as it was able to incorporate an entity. Now we know that incorporation of an entity is comparatively easier than closure of the entity. And if I can share, this is one of the deterrent and this is one of the factor which has consistently pulled down the ease of doing business ranking in the global index. And government is quite concerned about these issues from the time they have been working on ease of doing business in India. So they have been successful on one part, that they have been able to set up a mechanism which is seamless for incorporation and the other thing, barring the teething issues which we are facing due to V3. But other than that, they have tried their best to put the systems in place by which the incorporation of a company is now becoming a seamless. That is the objective, and which will happen over a period of time once the V3 issues are sorted. Now, they have now shifted the gear for doing a, you can say, a reform in closure of the business entities also. So first reform that they have done is the setup of the C-PACE, and wherever the bottlenecks government was feeling, the first bottleneck that after announcement of C-PACE, that was again brought to the notice of the government that, see, there may be a possibility that company was incorporated, but they could not do any business. They could not start their operations as are the conditions mentioned in section 248(1) itself. So why they are burdened that they should be required to file their financial statement, they should be burdened to file their annual return, and which is causing a lot of difficulty and delay also in terms of completing the compliance and filing the closure application. So government has in 2019 itself made the amendment in the rules by which they have provided that you need not file the balance sheet and annual return for the period in which you have not done any operation. So that if you have done any operation and returns are overdue, then you are required to file the return for that period. Let us understand this concept with the example. Let us understand that company was incorporated in the year 2020, let us say, and they have not done any business since incorporation. It was incorporated on 1st of January 2020 and has not done any business at all and has not filed any balance sheet. Now question is whether the company can file a strike off application without filing any of the financial statements for any of the previous year. Answer is yes, because the company has not done any business activity at all since incorporation. So only requirement is that they have to prepare the financial statement as on date, which is to be within 15 days from the date of filing of the application, wherein you will be displaying that there are no asset, no liabilities, and your registrar will be able to process that application without any difficulty. Now let us understand the situation B, wherein company has done some business starting from 1st of January 2020 to maybe let us say till 31st of March 2021. They have operated. After that, maybe there was a management dispute. After that, maybe the business in which they thought that this will be a successful venture, but it was not successful venture. Now they are sitting in June 2023 and they approaches you to seek a guidance whether I should file the balance sheet for the first financial year, that is for 2020. Maybe if the balance sheet was prepared for 31st March 2020, second balance sheet was prepared for or was due for 31st March 2021, up to which they did the business. And now third balance sheet was for 31st March 2022 and fourth balance sheet was for 31st March 2023, which is now current. Now, which of these balance sheets are mandatory? If they have done business up to 31st March 2021, the balance sheet and the annual return which are overdue, mark my words, what the law has specified is the overdue. Two words are important: has conducted any business, and the second word which is very important is the overdue. Now when your balance sheet or annual return becomes overdue is important. Let us say for 31st March 2023, my balance sheet due date would be the date of annual general meeting. Let us say typically my annual general meeting will take place on 30th of September 2023. So my balance sheet becomes due for filing on 30th of September 2023. And I get a time of 30 days to file this balance sheet. That is till 29th of October 2023, I have a time to file and my balance sheet will remain due up to 29th of October 2023. However, it will become overdue if I don't file on 30th of till 29th of October 2023. So my balance sheet is overdue on 30th of October 2023. If we apply this concept, we understand your balance sheet was overdue for 31st March 2020, then 31st March 2021, and 31st March 2022 also. How they are three different? You have done business for 31st March 2020. You have done business for 31st March 2021. But you have not done any business for 31st March 2022 because you stopped the operation on 31st March 2021. So you are meeting only one of the condition, but the other condition you are not meeting. So you are required technically to file the balance sheet and annual return for 31st March 2020, which is overdue because due date was, maybe if it was December, so 31st December 2020 was a due date. And if you have holded the AGM on, let us say 31st of December 2020, then after 30 days, yeah, that is on 29th of January 2021, it will become overdue. So as on 2nd of June 2023, when we are making this evaluation, the balance sheet is overdue for 2020. Similarly, for 2021 also, my balance sheet is overdue because the due date was, if AGM took place on 30th of September 2021, then balance sheet became overdue on 30th of October 2021. My balance sheet is overdue for 31st March 2022 also, but I am not qualifying the one of the condition that I should have conducted any business. So in this year, starting from 1st of April 2022, 2021 to 31st of March 2022, I have not done any business at all. So I don't qualify both the condition. So I need to file the annual return and balance sheet only for year ended at 31st March 2020 and 31st March 2021. And 2022 and 2023 are not required to be filed at all to qualify to the requirements what are specified in the amendment which has been again reintroduced. I'll not say it has been introduced because, as I told earlier, these changes were introduced in the rules way back in 2019 itself. They have been just skipped while the changes were notified for CPACE. So they have been inadvertently skipped, now just reintroduced to bring the position what was prevailing earlier. There is no single change in the language or intent. The intent remains the same. I hope this concept of overdue balance sheet and the business is understood by the learned audience, because this is very critical to understand. Otherwise, many people are having the apprehension that on one hand, it is giving the exemptions also. On the other hand, it is putting a obligation by way of an overdue return that you are required to, if you have done a business in any of the financial year for one day also, and you are required to file your balance sheet and annual return, then only you are allowed to do that. No, in a year in which you have done the business and the return has become overdue on the date of filing of strike off application, on that day, you are required to file the previous financial statements for that year. Otherwise, no. So if there is any confusion on this particular part, I think we can take the questions from the audience. I have one more point which I want to place before the audience for understanding this particular concept.
and I have a suggestion also, which I have given to ministry also in this regard. Under 248, if government has the intention really to fast forward the ease of closure of business in India, then government should delink the 248(2) with the requirements as are specified in 248(1). Because 248(1) essentially encapsulates A, if within 6 months of incorporation I have not commenced any business, which is not the condition in suo motu application of 248(2). So 248(2) essentially can be filed on one of the conditions that in addition to what is mentioned in 248(2), one of the ground is that I have not done any business activity in the last 2 years. Now, just imagine a situation that I have not done any business. Let us say, same example, 31st March 2021, I close the business. But if I want to file the application, because I have done business till 31st March 2021, there had to be 2 financial years which should pass. Then only I can file the application. So 21-22 and 22-23 should pass to make me eligible to file an application under 248(2). Because the condition that is specified in 248(1) is that in the last 2 financial year, the company has not done any business activity. Now, you imagine a situation if I change a small dot. I say that instead of stopping my business activity on 31st March 2021, I stopped my business activity on 1st of April 2021. Now, because financial year 2021-22 has been involved, I have to wait for 1 more year as per strict interpretation of 248(1). Now, interpretation is that I have to wait for 2 years, 2 financial years, in which I have not done any business activity. That means 21-22 I have done business, as I have done business on 1st of April 2021. What I have to do, I have to let 2022-23 pass as a first year and 23-24 as a second year. Then after 1st of April, after 31st March 2024, I will become eligible to file the application under section 248(2) on suo motu. This is, to my mind, deterrent. Once I have met the condition specified in 248(2), that is, I have extinguished all the liabilities and I have taken the approval of shareholder by way of a special resolution or 3/4 majority, then why I am required to satisfy this requirement of 2-year holding? And now on top of it, I'll tell one more point. The condition is that the same circular what Agarwal sir was referring, that has got amended recently, which has been reintroduced. The same circular also says, if ROC has issued under 248(1) any notice, then you have to file all the returns, irrespective whether they are overdue or not. Now, just imagine, in the same example, under 248(1), wherein the company has done business on 1st of April 2021 and closed the business. Now, I have a waiting period till 31st March 2024. I cannot file the application on my own. And ROC slapped a 248 one notice on maybe, let us say, 31st March 2024 or any date prior to that, I am gone. Because I was not filing the balance sheet for the year ended 31st March 2022 and 2023 in the hope that I will be able to file the closure application. Now, because I have not filed the balance sheet, ROC suo motu has initiated the action under 248(1) and I am gone. Now, my liability is that I have to pay the additional fees for the filing of all the annual accounts till date, and then only I can do the closure. And these are the reasons why many of the companies are not able to put forward their application. This is one of the reasons. I'm not saying this is the only reason. Many of the companies are not able to put forward their application because there are some management disputes. Me and Agrawal sir incorporated a company, and tomorrow there was some dispute in between, and neither me nor Agrawal sir is interested in closure of the company. This is also a large number of cases where these kind of situations are existing. So to begin with, at least if not much, at least one amendment can be done wherein 248(2) needs to be delinked from 248(1) so that the companies who are qualifying and who have extinguished all the liabilities and who have produced the certificate from a chartered accountant as are specified in 248(2) requirements and the rules made thereunder, then what stops the company from filing the application? And not only I'm saying about the private sector, even the government companies have also been mandated by Department of Public Enterprises by Office Memorandum of 2018, which was amended in 2019 and later on in 2022. That also specifies, even the cabinet has approved the closure of companies which are under government, that is CPSEs, are to be closed by using 248(2) mechanism. And they also are now struggling that they have to wait. Now, cabinet approval is there. Cabinet has decided on, let us say, 31st March 2020, that we have to close the company. But company is not able to proceed towards, because let's say they took 2 years time for extinguishment of liabilities, and they have carried out some business activity, not business activity, but there were some operations which are going on for the year till 31st March 2020 or maybe 2023. Now they have to wait for 2 more years as against the order of cabinet that they have to close immediately. But they cannot close because 248(2) comes on the way. And that is the suggestion that I had given. I think I've covered by and large the key
Yes.
issue regarding this, and I'll be happy to take the questions in this regard. Over to Agrawal sir.
Amit, there is a question for you. Can a company be closed if it has pending arbitration, legal cases with courts, pending income tax assessments? Amit ji? Can you hear me, Amit ji? Unmute, please. Unmute.
Pardon sir, if you are
Yes.
saying something to me, can you repeat?
Yes, yes. Just there is a query for you.
Yes sir.
Be closed if it has pending arbitration, legal cases with courts, and pending income tax assessments.
Yeah, that's a important question which I think I should cover. Now there is one change. If my voice is echoing,
It's okay.
It is
Continue.
okay. All right. All right. So what I am saying that there is a MCA circular of 2020, if I am correct, 2019 or 2020, I need to check, which says, which was in respect of CPSEs, that is the government company. And they have given a specific carve out for the government company, the companies who have given the VRS. And during closure, if there are some disputes which are going on, so in respect of those disputes, you need not wait for deciding those orders. You can straightforward go ahead and file the closure application. But in respect of other litigations which are ongoing, maybe income tax assessments, maybe your other, so how you will make your liabilities zero? The condition that is specified in the section 248(2), if you have some, let's say, income tax liabilities in respect of which the matter is ongoing before the income tax appellate tribunal, and you want to close that company, unless those matters are disposed of, you will not be able to file those applications, because how you will be able to prove it to the satisfaction of the regulator that you don't have any liabilities? So I don't think that there would be any situation where you have the pending arbitration, and pending arbitration you will be able to file the application. The exception that I just spoken about is regarding the employee related disputes which are with regard to their voluntary retirement scheme and the funds which are due therefrom. If the dispute pertains to that, because that was also done on the representation made by these CPSEs to the DP, that we are facing a lot of, as soon as the cabinet order comes with regard to closure, immediately the VRS is given, and after VRS, the natural reaction is that a lot of employee goes to the litigation. So we are not able to file these applications. So DP has made a representation to the Ministry of Corporate Affairs, and Ministry of Corporate Affairs has accordingly conceded to that request and allowed that filing of application. But in respect of other requirements, other litigations which are ongoing, there is even a section in the 248(2) application that you need to give a details of pending litigation. And I have seen that ROCs have been making the objection, and that's true, rightly, because if I make a strike off order, then who is going to bear those liabilities if at all tomorrow, by virtue of order of the court, some liability arises? So I think the settled position in this regard is very clear, that we have to get these litigations closed, if at all these litigations are going on, unless and until ministry comes out with some mechanism which can be put in place to give a very different meaning of the requirement of attaching these pending litigation. Because I don't think that there is any other way that government will be able to ascertain those liabilities and will be able to fix those amount in advance and ask the promoter to deposit those amounts in the court of law, and because with certainty it cannot be done, certainly. So that is the challenge, I think, with which they are struggling in this particular regard. So I've just informed with regard to the position, what is there in the
CPSE and the circular what was issued by the Ministry of Corporate Affairs in this particular regard. Barring that, the other litigations, I am of the view that they are to be settled before the filing of application.
Thank you. Thank you, Amitji. Amitji, tell me whether IT clearance and GST clearance is mandatory when company has not commenced any activity, or when a company stopped activity, but scrutiny assessment proceedings are not finalized. Did you get the question, Amitji?
No, sir. I'm so sorry. I'm on mobile and I missed out. Yeah, please repeat.
I'll repeat. Whether IT clearance and GST clearance is mandatory when the company has not commenced any activity?
No, it is not mandatory. It
Next
is not
question.
mandatory. As a matter of practice, if I can share, the registrar of company is sending the letters to the income tax department, and based on their feedback, if at all that comes in the specified period of time, they have that coordination with the income tax and the other departments, and based on the feedback they process the application. As such, there is no requirement for the company to secure the NOC from the income tax department or from GST department for filing the closure application.
Amitji, the next query is that when a company stopped activity, but scrutiny assessment proceedings are not finalized.
All right. So in those cases, assessment proceedings, if are not completed, then if you don't have a liability as on date, right? If income tax department has already determined some amount, let's say we were discussing about a case for 31st March 2021. We stopped the business activity on 31st March 2021, and we are going to file the application today. And for 31st March 2021, there is a income tax demand for, let's say, 10 lakh rupees. Already demand has been raised by the department. And now you may have gone into appeal, you may not have gone into appeal, whatever be the case. Until you dispose of that amount, that is a contingent liability on you. So you cannot file the statement by saying that there is a nil asset and nil liability. There will be a liability. So to my mind, you cannot in those situations. But if let us assume a situation that for 31st March 2021, you have filed the income tax return in due time, and no demand has been, maybe there was a liability of 1 lakh rupees which you have paid already. And now, as on 2nd of June 2023, there is no demand. You can very well close the application. And maybe tomorrow, if let us say the income tax department wakes up and there is a demand, they have all right that under 240, 252, they can go and reopen the company under 252. But as far as stopping of filing of the application is concerned, you are not stopped from filing. You can very well say that my balance sheet has, we have extinguished all the liabilities, and we are filing the application under 248(2).
Thank you. Thank you, Amitji. Thank you. Amitji, I'll bother you with one more this thing. As you're aware that the merger regulations, rules have also been amended. And some timelines, it's a very welcome change, have been laid down. Can you cover those changes in the merger regulations for fast-track mergers?
So maybe I can do little after I think Anjali ma'am is supposed to take one topic.
Sure.
If you can just take her. So I'll just try to change the internet connection. Maybe if it works, then I'll come on the computer system itself.
Sure.
So I'll do the presentation.
Yeah, you may join after Anjali is through. Friends, as happens every month. This month also, there are quite a few regulatory updates in securities laws. May I request Ms. Anjali Agarwal to take us through the regulatory updates in securities laws. Over to you, Anjali. Unmute Anjali, please. Unmute Anjali, please.
Hello. Hello. Am I audible?
Yes, ma'am, you're audible.
Yes, please continue. Anjali, start. Please unmute Anjali.
Good afternoon, everyone. I'm sorry for the technical glitch which happened, and as a result of which I was not audible. So when we talk about the SEBI regulations, SEBI amendments which have been introduced in the securities laws regime, first very important amendment is with regard to the introduction of the concept called legal entity identifier. So in this, till now, RBI used to have this concept of companies which were having an exposure of up to 25 crores, they were required to obtain this LEI code. But now SEBI has also mandated that any of the entities which have listed non-convertible securities or which propose to list any of the non-convertible securities are needed to take the LEI code from the regulators. LEI code is a worldwide concept wherein it is a 20-digit, 20-character code, and it is for easy identification of all the entities which engaged in financial transactions. So SEBI has given the companies a time frame up till 31st August to obtain this LEI and submit the same to the centralized database by 1st September 23. Shivam, next. Another important amendment which has been issued is with regard to standardization of the tripartite agreement amongst the issuer company or the exiting RTA or new share and the new share transfer agent which is proposed to be appointed. So in our real life, we see many a times it happens that the companies want to change the RTA. As per the listing regulations, though there is a regulation which talks about entering into a tripartite agreement between the company and the exiting RTA and the new RTA to be appointed, but there was no format to it. And there were, as a result of which the agreements were being drafted at the whims and fancies of the company or the RTAs. So now SEBI has introduced a model tripartite agreement which is needed to be issued, and all the companies and RTAs have to mandatorily comply with the same. RTAs even have to upload the same on their websites, and by 1st of June, the same is needed to be informed to SEBI. As per one of the conditions, if we go through the entire tripartite agreement, there is one important condition that the company has to appoint an independent auditor who will do a sample checking of the data that is being given by the old RTA to the new RTA, so that tomorrow the new RTA cannot say that I did not receive a particular data and I'm not in a position to give the DNR details or folio details of any particular shareholder because this data did not come to me from the old RTA. I think this is a very good move to remove the discretion which the companies or the RTAs were exercising. Now, a very, very important provision with regard to ICDR regulations. Underwriting, with regard to underwriting in IPOs and FPOs, this is an important provision which every company, every merchant banker, every underwriter has to keep in mind. When we talk of underwriting, there can be two types of underwritings, wherein we know there is a possibility that the IPO may not be fully subscribed or minimum subscription may not be achieved. This is called underwriting due to demand shortfall, or we in our technical language also call it hard underwriting. And the other underwriting may be because people have made the bids, but there have been technical rejections, as a result of which the minimum subscription amount is not being achieved. So this we call as soft underwriting. This is underwriting due to technical rejections. So with regards to the demand shortfall or hard underwriting, the underwriting agreement is required to be executed prior to the filing of red herring prospectus. While in the other case, that is technical rejections, the agreement may be executed after the pricing, but prior to filing of the final prospectus. So this is an important amendment which has come in, and the issuer company will have a choice. Shivam, just can you please go back? Issuer company will have the choice to determine which type of underwriting agreement it wants to enter into. Although when we talk about demand shortfall, herein companies remain assured that there will not be any sort of non-submission or non-subscription of the IPO, as it is because we have already entered into this kind of a underwriting agreement with a particular underwriter. Shivam, next. So, and an underwriter is not required to mandatorily subscribe himself or itself to the IPOs or FPOs. It can enter into arrangement with other parties to procure the subscriptions. Earlier, it was mandatory to do the underwriting themselves. And one more thing, that the underwriting price, predetermined underwriting, the underwriter's price cannot be less than the issue price. Shivam? Another inclusion which has been made, that pension funds are allowed to participate as anchor in the anchor investor category, and all the details have to be given in the material contracts and material documents. Detailed inclusions have been made. Shivam, next. Certain important amendments or we can call them clarifications have been issued by SEBI with regard to bonus issues. The eligibility portion, although it was there earlier as well, but now they have been clarified that at the time in the board meeting wherein you are announcing the bonus issue, you need to check the eligibility criteria. Earlier, there was not a clarity, and some of the companies used to take the benefit that at the time of allotment, we'll be complying with the requirements. So, but now it has been mandated that at the time of announcing the bonus, you have to comply with the requirements. One very important condition which was there in the discussion paper, which was even discussed in the board meeting, and now it has been made mandatory. There should not be any pending listing or trading approvals to any of the securities of the company when you announce a bonus issue, because there were cases, except ESOPs and any convertible securities, of course, because there used to be cases wherein companies used to announce bonus is needed to be mandatorily completed within a period of 60 days. But as a result of any unlisted allotment being there, so exchanges used to say that first go in for listing of those allotments, then only we'll be in a position to give listing for the bonus issue. So to avoid any such situation, SEBI has made it mandatory that there should not be any pending listing or trading approval for any of the securities. Allotment has to be made mandatorily in a demat mode. There were certain cases wherein the original holding of the allottee was in physical, and the companies were making the bonus issue as well in physical only, not in demat. Now it has been mandatorily made mandated that any allotment of bonus shares has to be made in demat mode only. So any shares which are in physical, the bonus issue in respect thereof would go in the IPF account. It will not be, the certificates would not be issued to the respective allottees. Now, XBRL Regulation 30. We keep receiving a lot of calls कि XBRL किस चीज का करना है, whether every announcement, whether every outcome is needed to be given in the XBRL mode. So SEBI stock exchanges have issued a list of compliances which are to be done mandatorily in XBRL as well. Along with PDF, they have to be given in XBRL. So some of the FAQs, important FAQs, which the exchanges have issued, and these are based on the queries being received by them and on the basis of the discussions with various participants. So first of all, first question is whether companies are required to file PDF form as well as XBRL submission. Presently, the answer is yes. Over a period of time, PDF submissions would be done away with and only the XBRL submissions would be considered. And we have to be, we as consultants, we as company secretaries have to be very careful that both the things are complied with. Then what is the timeline for submitting the XBRL format? It is 24 hours from the filing of the PDF disclosure. Whether PDF filing is being considered as compliance, presently, yes, but as I mentioned earlier, over a period of time, the PDF filings would be done away with, and ultimately it will be only XBRL form. Whether NSE also has the same XBRL? Yes, both the exchanges have issued their XBRL, created their XBRL utilities, and they have to be complied with. In addition to these, there was a discussion paper on delisting of the non-convertible securities, non-convertible debt instruments. The last date for it has already passed by. So that is why it has not been covered. But otherwise, that majorly talked about any company having more than 200 non-QIB investors that cannot be delisted. But companies having less than 200 investors can be delisted by following the procedure which was proposed in the discussion paper. That again is an important piece of document for each one of us, especially for the companies whose NCDs are listed on the stock exchanges. So that's it from my side.
Thank you very much, Anjali, for taking us through the updates and very explaining in very simple language, very clearly bringing out the implied intentions. Friends, our next expert is Ms. Nikita Vijay. She will take us through a quick take from SEBI consultation paper on framework for mandating additional disclosures from FPIs. And there is another SEBI consultation paper, a very important consultation paper on draft of the proposed prohibition of unexplained suspicious trading activities in the securities market regulations. That means a new set of regulations they propose to come out with. And Nikita will also cover on fin influencers and the Supreme Court order in the matter of Hindenburg and Adani. Over to you, Nikita.
Thank you so much, sir. Firstly, I would like to, am I audible?
Nikita, 1 minute.
Yes, sir.
These two consultation papers, we propose to hold a very detailed seminar on 9th of June.
Yes, sir.
So quickly cover this to give so that our participants can come out with their queries in the next webinar.
Sure, sir.
Yeah. please
So,
begin.
starting with, thank you so much, sir. So, starting with the consultation paper that SEBI has proposed on the FPI regulations. So, looking at the recent fiasco regarding the Adani Hindenburg case, when SEBI has been facing challenges to find out who are the original beneficial owners behind those for foreign portfolio investors which have invested in the Adani stocks. So, considering that, SEBI has come up with a proposed amendment in the FPI regulations, where they want to propose the changes which can ultimately help them detect the persons who have the actual economic interest. So the difficulty that they were facing were currently there were layers and layers of corporates in the which are the investors in the FPIs, and irrespective of structure, the removal of opaque structure that they wanted to pursue in the wanted to harp upon on the FPIs. Still, there were some amendments in 2018. That, because of that, they were not able to assess the persons who were the actual individuals having control over those FPIs. So the detailed amendment, detailed structure regarding this proposed amendments, we will be discussing in our next seminar. Coming to the second consultation paper, which is related to the prohibition on the suspicious trading, SEBI wanted to, with respect to the fraud and insider cases, which have been coming up on SAT level and Supreme Court, there is a concept which is called preponderance of probability. So what SEBI has covered in this consultation paper is, due to the high-tech encrypted messages services, due to the high-tech tools used by these perpetrators, they are unable to assess the connection. They are unable to find, because of their regulatory restrictions, because they don't have any access to they have the access to the call data records, but they do not have any access to the call recordings. For example, this is just one example. They also stated that due to this Telegram messages, these WhatsApp encrypted messages, they are unable to establish a connection, which ultimately goes into SAT, and Supreme Court says that there is no nexus or there is no evidence of preponderance of probability. So to curb this and to catch the real perpetrators, now SEBI wanted to come up with a enhanced version where they want to penalize or initiate proceedings against the persons who they feel have done the suspicious trading. And they have come up with a methodology, certain methodologies to detect that, which we will discuss in our next webinar. But the crux of this consultation paper is that they wanted to come first one step ahead for the preponderance of probability. Secondly, they want to shift the burden of proof on the person who has been alleged of doing the suspicious trading. So it will be very interesting to see, although they might catch many perpetrators because of this regulation, but it has also seen in the past that many innocent investors are come under the garb of these proceedings. So it will be very difficult for them to prove something which is negative, which they have not done. So we will have to see, we will discuss both of these in detail. So currently, now I would come to the Adani Hindenburg report. So as you all know that there is ongoing, Supreme Court has framed a panel which is headed by Justice Abhay Manohar Sapre, and has come up with a report on 17th May on the hearing. They have provided a very detailed 173-pager report, where their main focus was to see whether there is any regulatory failure on part of SEBI while investigating this Adani fiasco. So as you all know, on January 24, 2023, so there are many aspects of it that I will break down and explain how the panel has actually summarized it, and what are the suggestive measures they have provided to SEBI so that they can enhance their current regulatory framework and protect the investor, which is the sole aim of Securities and Exchange Board of India. So on January 24, 2023, a Hindenburg research report came into the media, and due to which the Adani stock faced a lot of volatility. And there were many things which were stated in the report, which was actually a culmination of the disclosure that have been made by Adani in the different public forums and to public disclosures. So when Supreme Court has framed this panel and has directed SEBI to investigate the matter, so there were three main concerns that was regarding these Adani stocks. Firstly, they were concerned whether there has been any breach of the minimum public shareholding. Secondly, they wanted to assess whether there has been a proper disclosure of related party transactions or not, which concerns the parties to SEBI in accordance with law. Thirdly, whether there has happened any manipulation of stock prices in contravention of existing laws. So, and the panel's duty was to, so SEBI is investigating this matter, has sought time to prepare its report. And on the other hand, the expert panel, which has the experts regarding to the financial and securities market, they had the duty to assess whether the situation, including the relevant causal factors, have been led to the volatility of in the securities market or not, whether there has been any regulatory failure in dealing with these alleged contravention, or to suggest measures to strengthen investor awareness. Sorry. So on 6th May, committee has presented its reports to the Supreme Court. In a nutshell, regarding the volatility, they have stated that it is market parties. So what is volatility in the market? How the shares, prices, and volume move due to various public disclosures and other factors that influence the price and volume. So it is also the demand and supply is also one of the factors. Based on their assessment and expectation, the assessment and what is the information which is available in the public, which actually influence the investors' decision to buy that stock or not. So as per the panelists, as per the expert panels, they said that actual volatility happened after this Hindenburg report came into the public. And there has been they said that there has been no volatile before this Hindenburg report has actually came. Even during this time, Adani Group also took some steps to mitigate the measures. They pared down the debt secured by encumbrance on their shareholdings. They have also infused fresh investments into the Adani stock by way of investment of nearly $2 million by a private equity investors to build confidence in the stocks of the general investors. Secondly, what has observed by the panelists is the investor awareness. So you will be surprised to know. So in between 2019 and 2022, the trading by the individuals in the Adani stock was approximately 67% by value by the intraday and 33% in the delivery of shares. If you see the empirical data, there are top 10 brokers in equity FNO has been increased by over 500% in financial year 2022. So approximately 88% of the individual during this scenario 2019 and 2022, there were 88% of the individual traders who were active traders in the market. Further, the committee also noted that there was a high increase in the number of intraday traders. SEBI has identified that there is a need of, SEBI has identified areas that need attention, has briefed the committee on its plan to address these areas. So to make the securities, as I said, the securities market is meant to function on the premise of investors making informed decision. Stock trading is almost entirely digital, even at the consumer's end. So whatever has been disclosed in the media, what are the disclosures? It has been felt by the committee that there are so many disclosures that sometimes the key disclosures gets lost in the whole bunch of, and the investors are not able to make a informed decisions. So next, they have also assessed that whether there has been any regulatory failure on part of SEBI or not. So they were, first was the minimum public shareholding. So there was allegation that the 13 overseas entities are actually indirectly connected to the Adani promoter group. But due to, as I said, that there was a difference in the regulation at that time. Earlier, it was the ultimate, they have to disclose the ultimate beneficial owner, but later on, they streamlined the definition with under the rule line of the PMLA, due to which they were able, the FPIs have made the appropriate disclosures, but still who was the person who has the economic interest behind these FPIs is still unknown because of the rules, regulation that were enforced during that time. So SEBI has put their queries, concerns that there are a lot of countries where these layers of corporates are situated. So it is difficult for them to fetch all the data. So that's why they have also sought time. So secondly, in these circumstances, panel was of the view that there was no as such a regulatory failure because they have assessed the FPI disclosure as per the enforced regulation at that point of time. Secondly, the area of concern was related to the related party disclosure. Even in this, the related party and related party transactions, there was an amendment which had come in November 2021. But they have said that it has a prospective effect with some changes taking effect on April 1, 2022 and 2023. So India has amongst the widest definition of these terms across jurisdiction that has been noted by the panelists. So it is very, it will be very interesting to see that so long as of now, they have concluded there has been nothing unreasonable or subversive which could conclude that there was any regulatory failure. Again, because the regulations that was in there at that time, whether there was any related party disclosures which was with the subsidiary of the company, or there has been a related party transaction which could impact the related party indirectly. Whether there has been any such transactions, they are in the amendment. So as of now, so they have concluded that there has been no regulatory failure by SEBI. So now coming to the third thing that committee has said, that they have identified 13 specific transactions where they are investigating whether they are related party transactions or not, from the standpoint that they were fraudulent. So SEBI is actively engaged in collecting the data on this transaction. The committee would therefore be unable to comment with further input except to say that investigation must be completed in a time-bound manner in accordance with law. In addition to this, with respect to the price manipulation, the committee has said that there are numerous alerts and numerous surveillance system that has been embedded by SEBI, which includes what is the concentration of net buyers or net sellers, what is the contribution of net buyers to the increase of the last traded price during a price rise period, what is the contribution of net sellers during the price fall, whether any group of entities traded among themselves which might have led to increase or decrease in the price, and so on. So based on these alerts, they have also taken an example of trading in the Adani. So there were in total 849 alerts that have been generated and were considered by the stock exchanges. They have initiated four reports to SEBI. Stock Exchange has given 4 reports to SEBI. 2 was before the Hindenburg report and 2 after January 24, 2023. So taking an example, SEBI has explained the analysis done taking the example of Adani Enterprises Limited. So their trading was divided into 4 patches where the stock price rose significantly. But when they analyzed the trading, in a nutshell, they found that there was no artificial trading. There was no wash trades among the same parties multiple times. In one of the patches, FPIs under investigation was the net seller, and one investing entity that had purchased across the patches had purchased far more of the other securities. So there was no coherent pattern of abusive trading that has come to light as of now. So when SEBI, or when there is any investigation in the securities market, they also see that what is the trading pattern of that particular entity, whether they are only investing in the Adani stock or whether they are investing in other scripts also, whether the person is a regular investor. So considering this, they have not expressed any opinion on merits as of now, but they have said that there has been, as of now, there's nothing come on light which could say that there has been any malified or any artificial trading going on in the Adani stock. So the most important thing that panel has addressed a lot of current regulatory framework which is going in SEBI right now, and has also suggested various measures that how they could improve it. So there are 2-3 suggestions. I'll just tell you in brief. There are 2-3 suggestions that they are proposing to make that SEBI should consider before examining in any matter. One of the most important suggestion they are stating is that when there are a lot of whole-time members and adjudicating authorities in SEBI who are actually dealing with similar kind of cases, but when SAT or Supreme Court has made an opinion on one aspect, so there should be a parallel uniformity in the decisions given by the other whole-time members and adjudicating authorities. Secondly, they have also said that the investigation should be in a time-bound manner. So as of now, there is no limitation on SEBI when to conclude proceedings and what is the and how much time they should complete the investigation. So there has been a lot of cases. Even recently, there has been a cases of in SAT Jolly Plastic versus SEBI, where the violations of PFUTP was of 2012, but the SCN was issued in 2021. That is 9 years later. So the SAT held that delay itself causes the prejudice and order was quashed. In similar matters, there have been plenty of matters where SAT has taken this view that the investigation should be in a time-bound manner, because the ability to defend the case also lost in this, also loses because of change of employees, non-availability of the documents, and there are a lot of changes in the corporate structure, change in ownership, and so on. So that is the second suggestion that they have given. Thirdly, they have also said that there should be a difference in the quasi-judicial, who is a quasi-judicial authority, and who's the investigating authority. So they have taken the examples of CCI. So in the CCI, the quasi-judicial authority take a prima facie view, and they give this matter to the DG, and they given the timeline within 60 days the investigation should be completed. If they have not come, if the matter is complex, so they can seek extension with the reasons accordingly. So the second layer, the third suggestion that they have given, there should be a clear demarcation between, because SEBI is one authority who is a legislative authority also, who makes rules and regulation, who is the licensing authority, who gives license to the intermediaries, who govern the intermediaries. Then they are also born with the investigating power also. They can investigate if there are any foul plays in the securities market. So accordingly, they have suggested that there should be a segregation in all those powers. And fourthly, they have also given a very interesting suggestion, and that has already been recommended to SEBI, that there should be a, if the matter has separate legs which involve separate experts to assess the matter, so there should be the government should form a designated designated expert panel committee sort of body. So the matter is being assessed in a 360-degree angle by the experts with respect to financial and because sometimes the share trading has other aspects also. There are tax issues also. There are other foul play which is identified. So rather than separate agencies are regulating this separately, it can be done under a expert committee, which would be disbanded once the investigation is over. So this has been now we have to see how SEBI will come out with their report, how the investigations will conclude. So if you see that as per the expert panel, there has not been as such any regulatory failure, but they surely suggest that there should be an enforcement policy which they should follow and inculcate all these provisions and in all these suggestions that have been given by the expert panel committee. Now, coming to the second topic, it's about the recent SEBI's probe on the financial influencers. So you would see that they have been in COVID-19 and the rise of the digital era and the rise on the investing in cryptocurrency and stock market during this period has given birth to the new age content creators who are termed as financial influencers. Recently, also one SEBI has settled one case in approximately 6.5 crores, and SEBI has been saying that they are coming up with a regulation so that they can curb this financial influencer activity. So I would just want to give you a little background that how there are two regulations which are in place for this. One is the investment advisor regulation, and second is the research analyst regulations. So as of now, if you see the definition, in fact, in the IA regulation and the research analyst regulation, the financial influencer not exactly nowhere falls under the IA or the research analyst. So there has been also one more case where SEBI has to let go a financial influencer because they were not actually coming under the definition of either the research analyst or the investment advisor. So they have recently on April 2023, they have also come up with an advertisement code. This is actually one of the steps to control this activities of financial influencer, and the investors are protected. So they have come up with an advertisement code where they have broadly given the guideline that if they are giving any statement or any kind of advice or anything like that, they have to take a approval from BACL, which is the subsidiary or sort of thing of the Bombay Stock Exchange, which has been authorized to regulate the this investment advisor. This also SEBI has recently given the license to the BASL to regulate the investment advisors. And if you see the regulations pertaining to the this financial influencer in Australia and UK. So UK also has a cap code which also gives a broad outlines that how these social media influencers should be regulated. But in Australia, they have more robust regulations regarding the regulating of this financial influencers. So in Australia, they have said that if there is anything which is not a statement, which is not a fact, and you are stating something that buy this stock and hold this for this much period and you will get a profit, so that will be a violation of law. So that will be something which you are doing to influence the investors, and you don't have a license to act as a investment advisors. So SEBI might consider all these regulatory framework that are being adopted by the other countries while regulating the financial influencers. Thank you, sir. Thank you from my side.
Thank you very much, Nikita. Very well done.
Thank you, sir.
We look forward to a very robust presentation from you on 9th of June. Now, we know that Section 233 of the Companies Act provides for fast track mergers, and rule I think 25 of the merger rules deals with that. Now there has been a very welcome amendment in that particular rule. We can request Mr. Amit Gupta ji to take us through. Over to you, Amit.
Yeah, thank you, sir. I believe I am audible.
Yes, you're audible.
All right, sir. All right. So, as Mr. Agrawal was saying that it's a welcome move. Indeed, it is a welcome move because in 1956 Act, though there was a lot of demand from the industry that there should be the restructuring facility on the lines at par with the global regime. Like we know many of the countries, many of the territories, the merger and amalgamation, or more commonly we call a restructuring, is by way of a contract. You just have to, where the regulatory interference is very minimal, where the judicial intervention is not there in many of the jurisdiction. On the same line, Government of India first time, while framing the Companies Act 2013, introduced the concept of fast track merger. Though of course with lot of conservative approach, they provided the applicability of this concept only limited to a certain class of companies. They provided certain checks and balances to test the water. Of course, government is in middle of doing a mega reforms in respect of entire lot of restructuring on lines of the global footprints on the restructuring. And I'm sure in times to come, the mergers and amalgamation and the entire scheme of restructuring would be a matter of contract, at least in respect of these small companies and the holding company and the wholly owned subsidiary to begin with. Maybe it may be extended to the other larger entities as well. So we know how important is the role of restructuring in the inorganic growth of the corporate. So to boost that, government introduced the concept of fast track merger. And as you know, the eligibility norms in respect of the fast track merger, which is captured in 233, talks about that this is possible to be done only if the transferor and transferee company both are either a small company or it is one is holding company and the other is a wholly owned subsidiary. So wholly owned subsidiary can merge into holding company. There is no restriction, which can be transferor company, which can be transferee company. There are many questions in the mind of learned audience. As I know, many of questions, many of people are asking whether transferor company can be a wholly owned subsidiary and transferee company can be holding company. This is a plain vanilla case. We know this is very well possible, and 90% of the merger, the wholly owned subsidiary company is merged with the holding company. But the other situation is also possible. There is no restriction as such in section 233 concept is concerned. Similarly, the merger between the two small companies is also possible. So we'll quickly just run through and to understand what the change has happened and how it is going to make our life easy in respect of the fast track mergers. So as we know, there are certain other conditions like both of these entities needs to be solvent. The solvency certificate is required because this is again, as I told, that Government of India wanted a conservative approach because they wanted to test the water first
and they wanted to extend this provision to the other also. So maybe in times to come, the solvency requirement may also go away. You don't know, because that has been demand from the corporate key as to what we are trying to achieve. Because if it is a merger between the holding company and its wholly owned subsidiary, then how really does that matter whether the wholly owned subsidiary should be a solvent entity or not solvent entity? So we can discuss and debate those things as and when the things progress and the government is in process of bringing those mega reform, and once the discussion paper is out, I think that will be the right time. As of now, the process that typically corporates were following was that they were preparing a draft scheme, and the draft scheme was circulated to the registrar, to the official liquidator, where the registered office of the transferor and the transferee company used to be situated. And objections were invited from these authorities in respect of the proposed scheme. And typically we know objections were coming or not coming. There are different practices across the country. Few of the registrar of companies have not been giving any objection at all at this stage, where the company was filing the scheme, asking the registrar and official liquidator to give their comments. Many of the ROCs were giving their comments also on these schemes, but there were ROCs who were refraining from the comments at this stage. So naturally the 30 days time will pass. If you have received the comments, you will incorporate those changes in the scheme. You will go before the shareholder and get your scheme approved from the shareholder as well as creditor. There are certain conditions that you will require the 90% of the consent of the shareholder. Similarly, 9/10 of the majority from the creditor also had to approve. So those are the conditions which are easy for the company, because these are all closely held companies. There is no difficulty that in many of these entities, even the creditors are not there, or even if creditors are there, they have no objection for your restructuring proposal. This is done. So this is sorted. There is no change introduced in any of these provisions so far discussed. Now, this scheme, whatever is approved by the shareholders and the creditors, is required to be submitted to the central government, that is the regional director. And of course, you will submit the copy to the registrar and the official liquidator where the transferee company is situated. This is required to be submitted only by the transferee company. And now comes the change. Now, what was the position? Here it is, up till this stage it was fine. You have filed the scheme. After filing of the scheme, there was no timeline prescribed, because from here the provision that was dealing with this particular timeline, which is Rule 25(5) and 5(6), that comes into picture. And the old law, the old rule that was prescribed by the Ministry of Corporate Affairs was reading that where no objection or suggestion is received to the scheme from the registrar or OL, or where you have received the objection from registrar or OL but is not sustainable, the central government shall issue the confirmation order. Now, this is very open-ended statement. In what time the registrar was required to make the objection, and in what time the regional director to whom this power was delegated is supposed to issue the confirmation order, there was nothing mentioned in this regard. The only thing that was mentioned, that was in 233(4), from where some guidance was available, which was saying that if the registrar or the official liquidator has any objection, he will communicate those objections to the RD within period of 30 days. And if he does not communicate, then it will be presumed that he has no objection at all. And the RD is free to proceed for issuance of the confirmation order. And as all of us are in practice, we understand. In practice, even the objections which are raised beyond the period of 30 days are entertained. A. B. There was no timeline in which the regional director will issue the confirmation order. That is what the challenge was. So you were not having any certainty. The professional fraternity was not able to give any confirmatory answer to the client as to by when this fast track merger, which is so-called fast track, will actually get completed. And in many of the cases we have experienced, this fast track really has become the long track. The two simultaneous mergers which we started, one through NCLT and one through fast track, are non-fast track, which is through NCLT, completed much earlier than the fast track one. So the fast track merger was taking a long track. This is the experience with many of the professionals. I'm not saying in general or specific about any particular registrar or the northern regional director or any regional director, but I'm saying in general, the practices are varied all across the country. To bring uniformity and also to meet the citizen charter to provide to the corporate a definite timeline so that they can plan their next level of activity. Because restructuring is just one of the activity that they are planning. The more and more integration is on the part of the operations. So the corporate will be able to now plan much in an advanced manner as to these are the timelines, and these timelines will be able to conclude our restructuring. And after that, we will get the order. After that, we'll file the order. After that, we will integrate the operations, right? So integration of operation, integration of employees, integration of other ecosystems, taking necessary approvals will all now have a certainty. Now, what is the change? That is important to understand. The change is essentially in 25 Rule 5 and Rule 6, Sub-Rule 5, Sub-Rule 6. Now, Sub-Rule 5 now says that where no objection or suggestion is received within a period of 30 days. So there is no change in the period of 30 days as the time was specified in 233(4). The time has now been recorded in the rules also, that if no objection is received within a period of 30 days of receipt of copy of the scheme by the regional director from the registrar of companies or from the official liquidator, and the regional director is of opinion that the scheme is in the public interest, which is one of the conditions, and in the interest of the creditor, it may within the period of 15 days after expiry of 30 days issue the confirmation order. That means in all 45 days is the timeline in which the confirmation order has to be issued. So you file the scheme today, after 45 days the confirmation order will be issued by the regional director. 30 days time as specified in 233(4) continues to be the same. The ROC and OL will continue to have 30 days time for filing their objections to the scheme, and the regional director is required to satisfy the public interest and the interest of the creditor, and in next 15 days he has to issue a confirmation order. Now, proviso to this sub rule is also there that says if the central government does not issue the confirmation order within the period of 60 days, that is another 15 days time grace has been incorporated in the proviso itself. That all right, 45 days time is there, but still I believe there is a time given by virtue of this proviso that all right, still you issue in next 15 days, all right. But if it in 60 days, if you don't issue, then it shall be deemed that there is no objection to the scheme and a confirmation order shall be issued accordingly. That means your scheme will become final and binding on expiry of 60 days. That is the, I think, game changer for the small and medium enterprises which are qualifying as a small company in terms of the Companies Act definition, startups basically, and also in respect of holding company and wholly owned subsidiary. And similarly, so this is one very big change. Now, there may be questions. I'm sure many of the peoples will be asking a question, which is my question also, as to who will issue this confirmation order after the period of 60 days. What if RD does not issue the confirmation order after 60 days? Because RD himself is obligated to issue the order within 60 days. That is the timeline that is provided. Now, if he does not issue, is this power going to the Ministry of Corporate Affairs, or we will, whatever scheme we have filed, we'll assume that that is the order and we will file the copy with the registrar in form INC 28 as if this has become the confirmation order because the time of 60 days has passed. So these are two options which are probably available. Either this confirmation order will be issued by the regional director or by some other senior officer that may be nominated by the Ministry of Corporate Affairs for purpose of issuance of this confirmation order if the timeline what is prescribed in 25(5) is not adhered to by the concerned authority within the particular frame of time. Then whether this option or the other option is a point on which we are contemplating and we are seeking necessary clarification, or in times to come as we are filing the scheme, we will also get to know how the government intention. But one thing is very clear, whatever be the case, at least a regulatory discipline has been introduced by the ministry that now regional director also is bound by these timelines, that he has to pass an order, which is I don't know, means the current state. I think the peoples who are appearing before the regional director, they will know how much is the backlog. The cases which are filed today for the purpose of fast track merger consideration are seeing the light of the day, maybe with the pendency of 60 days, 90 days, right? So now prescribing a timeline of 15 days, that in 15 days of time he has to dispose of, I think is a big message to the regional director offices that the Ministry of Corporate Affairs has given by making this amendment, that they have to change the order in which they have been functioning. They have to assign a priority to this particular task that has to be completed in a time-bound manner. I think that is the message what I am understanding from the amendment that has been made. Now,
The other important change, I think I'll take just 2 minutes more and then we can open the question answer. The sub rule 6 that has been amended, which says that where the objection or suggestions are received within the period of 30 days, what will happen? Such objection or suggestion of the registrar or OL can be sustainable or they can be non-sustainable. Now, if they are not sustainable and RD is of the view that in the public interest or in the interest of creditor, within the period of 30 days, after expiry of 30 days, issue the confirmation order. That means 30 plus 30, in 60 days time, he has to issue the confirmation order in net. Even if you have received the objection, but objections are not sustainable, then in 60 days time in net, you will issue the confirmation order. No change. Now, if the central government is of the opinion on the basis of objection or is of the view that this scheme is not in the public interest or in the interest of creditor, as we know that they have an option to refer the matter to tribunal, which was there earlier also, it is nothing new. Now, only thing was that there was no timeline prescribed in which they had to refer the matter to NCLT because they were having no option to reject the scheme. There is no option to reject the scheme by the regional director. That is the beauty of fast track merger scheme. That is the way the entire scheme, the entire section 233 was framed. The RD was having a power to approve the scheme, and if he is of opinion that this scheme is not in the public interest and in the interest of the creditor, it may at max refer the scheme to the National Company Law Tribunal. Earlier there was no timeline. Now 60 days timeline has been specified. That is, either in 60 days you will approve or within 60 days you will file the matter before the National Company Law Tribunal of the concerned jurisdiction. Now, Form CA 13 has been specified, and you will have to state the objection, whatever you are having, or the reasons that why you are saying that this scheme is not in the public interest or in the interest of the creditor. CA 13 was earlier also there. Form remains the same. There is no change in the form. But the crux remains that what we have discussed in 25.5 and 25.6, there is a timeline in which the regional director, essentially the time in which the ROCs and official liquidator were supposed to file the objection, that was earlier also 30 days, now also 30 days. There is no change in that timeline particularly. But yes, the regional director is principally obligated that he has to approve the scheme within 45 days. And in 60 days, if he does not do that, then in 60 days time, it will be considered as a deemed confirmation if there is no objection. If there is an objection, then even either in 60 days he will approve, or in 60 days time he'll file the objection or his justifications of not approving in the public interest or in the interest of creditor with the National Company Law Tribunal of the concerned jurisdiction in the form CA 13. There is no option other than these two timelines, whatever has been mentioned. So I completely agree and echo with what Mr. Agrawal has as an opening sentence mentioned, that this is a remarkable change that the Ministry of Corporate Affairs has done.
And I can see that there is lot of discussion that has gone in the ministry in bringing this change, and I see this change only as a just one precursor to the big change that is going to be introduced in times to come in the space of the restructuring by the Ministry of Corporate Affairs, as we have been debating for quite long, that why at all the schemes are required to be placed before the National Company Law Tribunal. What does they really do, and what is the value addition if they really do have a power to go against the wisdom of the creditor and shareholder once they have approved the scheme. So these are all debates, but yes, I think it is a step in a right direction where we have now agreed on a particular time frame that we will complete this particular thing in this particular time. So I am done with my sharing of thoughts, and I'll
Thank you very much.
pick up some questions if we have.
Thankful to you for sparing your valuable time. And we received a few questions, and we have answered all the questions. So there is no unanswered questions as of now. Friends, on my own behalf and on behalf of all of you, I wish to pose a hearty vote of thanks to our very learned faculty, Shri G.P. Madan ji, Amit Gupta ji, Anjali Agarwal, Nikita. They have very well taken us through the regulatory and legal updates. And friends, the entire updates are covered in our CP Connect, which has already been, I think it's in the process of being mailed to you. You'll be receiving very shortly. And our journey of knowledge sharing will continue. And as already informed to you, 9th of June, Friday, from 4 to 6, we are going to take up the two very, very important SEBI consultation papers. I have gone through the two papers. They're quite, I don't know, there's a lot of challenge in that. So needs to have detailed discussion and deliberation on that. So on 9th of June, we meet to discuss the SEBI consultation paper on framework for mandating additional disclosures by FPIs. And there is also a new law which SEBI wants to bring, that is the prohibition of